last but not the least is Puttaswamy. The Puttaswamy has 2 judgments. I didn't give you the last 2 of the item numbers of your list, but you can you will page and all, you will be able to see item 47. Puttaswamy will be 48 and 43. 2 of them are Puttaswamy. So in this Puttaswamy also, first judgment is about whether privacy will come under Article 21. Yes, it will come under Article 21 is the lead judgment. But subsequently, when the Aadhaar Act was enacted, UIDAI authority was brought in. That was challenged. Several provisions were challenged on several angles. Justice Sikri wrote for Chief Justice Deepak Mishra and Justice Kanvilkar. That was a majority judgment in which they said Aadhaar Act is valid and it does not affect the right to dignity and the 2 facets of dignity, that is individual dignity and the community approach to the dignity. And specific provisions of the enactment were struck down. That is in para 513 that has been struck down. There is a discussion about what are the provisions which are struck down, and the findings you can see from paras 351 to 368 about the validity. And Justice Chandrachud gave a dissenting opinion saying that the act is unconstitutional. And the one angle which was discussed in this is about what is privacy angle is the first judgment. The second one describes what is proportionality. Whether there are 3 tests in this judgment, what is important is that the 3 tests which were given for checking of the enactment, testing the validity, is the 3-fold test which you will find in para 975 also, is the legality, which postulates the existence of the law, the need defined in terms of the legitimate state aim. Thirdly, the proportionality, meaning which ensures a rational nexus between the object sought to be achieved and the means adopted for getting the legislation in place. So these are the tests. While the majority opinion thinks it passes all the tests, the minority thinks it does not pass the test. So therefore, there may be a very important question regarding Aadhaar or the Puttaswamy or something. Is, in my understanding, this is one of the very, very important. I'm not, I can't vouch for whether it will come or not, but I can tell you, in my view, this is one of the very, very important judgments, both the Puttaswamy judgments. Please go through them. Some paragraph numbers, I can tell you, even Justice Bhushan had also given some, his opinion separately. Justice Bhushan had given a concurring opinion, but he had been a little more conservative as far as the enactment is concerned. He had in fact said, certain provisions which were held by the majority as valid also, he said it could not be some provision. They are valid, he said. So it can't be treated as a money bill is what Justice D.Y. Chandrachud said, whereas the majority says it can be. So please go through this. And certain directions have been given in that judgment as to where it can be applied, where the Aadhaar cannot be made mandatory. That is also given in this majority judgment as to where it cannot be used. That you can find in para numbers 378. And Aadhaar and PAN linking is valid, and whether it satisfies the test, please understand that paragraph 486, 503 and 512. Kindly see those paragraphs there are, and kindly see how to read a finding in a judgment and ratio decidendi. So you will be able to give an answer to the questions. Therefore, I would request all of you to please read the questions twice before